Hello everyone. Today we are going to start a lesson Indian Judiciary. What is judiciary? Judiciary is derived from the Latin word judiciaris meaning of or belonging to the court of justice. Judiciary is a third branch of government, is probably the most important branch of government to keep check on legislature and executive. Judiciary protect the laws by punishing those who break them and protecting those people who have been denied what is rightful there. What is the role of judiciary? Let's see here. Role of judiciary. First one, judiciary resolve dispute between people and government, and between governments. Judiciary has power to cancel laws passed by parliament if they violated the basic constitutional structure. Citizens can approach the court if they are believe that their fundamental rights have been violated. The court has bound to help them in a manner concerned. There are two types of judiciaries. One is civil, another one is a criminal. Civil cases refer to those that involve dispute over property, money, inheritance, marriage, matters related to rent, etc. While criminal cases refer to those that involve dispute over physical injury, robbery, dowry, murder, etc. The structure of Indian judiciary is a pyramidal in nature. There are three levels of a court. There is the one apex court, namely the Supreme Court. It is the highest authority. Below the Supreme Court, the high courts located in each state. Some union territories have a common high court. Subordinate courts come to bottom of the pyramidal structure. District courts, Nyaya Panchayat and Lok Adalats are some of the types of subordinate courts. The decision of the Supreme Court is final, is binding to all other courts. The courts of India are interconnected to one another. If the citizen feels that the decision given by the lower court is not just, he or she can appeal to the higher court. Supreme Court of India is the apex of the entire Indian judiciary. It came to be on 28 January 1950. The inaugural proceedings of the Supreme Court were carried out by the Chief Justice Harilal Kania, along with the five other justices. Supreme Court of India promised that comprised the Chief Justice of India and 25 judges who are appointed by the President. Certain preconditions are required for an individual to be eligible as the judge of the Supreme Court. First one, that is, he or she should be Indian citizen. Second, he or she should have been a judge of one or more high courts for a minimum of 10 years. He or she should be an advocate of high court for at least 10 years. The president should consider him/her to be distinguished jurist. The Supreme Court retire at the age of 65 unless he or she resign or removed by the presidential order. A Supreme Court judge can be removed from office only if the president pass an order on the ground of proven misbehavior or incapacity. Both the houses of a parliament have to pass the address of removal. The address should be supported by two-thirds of members who are presenting and voting. Functions of Supreme Court. There are three functions of Supreme Court are as follows. There is original jurisdiction, appellate jurisdiction, and advisory jurisdiction. In original jurisdiction, the Supreme Court allow it to settle dispute between two states, between a group of states, between Government of India and a state. It's also solved dispute between Government of India with one or more states on the one side and a few states on the other. The Supreme Court also have power to transfer cases from one court to another. It can withdraw pending cases or dispose of them. It feels that they are similar or identical to each other. Appellate jurisdiction of a Supreme Court refer to the power to hear appeal from the other courts under it. The Supreme Court can hear appeal under the following categories: civil cases, criminal cases, and constitutional cases. In civil cases, Supreme Court hear appeal in the cases that involve laws that are important to all citizens of the country, or if the High Court asks the Supreme Court to decide on the particular case. The Supreme Court listens to appeals in criminal case on the three conditions. If the High Court reserve an order to acquittal of the accused and sentence him or her to death. Second, if the High Court has taken a case from the subordinate court and sentenced the accused to death or imprisonize him for life. Third, if the High Court decide that the case if fit to be appealed in a Supreme Court. In constitutional jurisdiction, the Supreme Court also hear cases which involve the interpretation of the Constitution. The case could be civil or criminal. Advisory jurisdiction. The Supreme Court has advisory jurisdiction on the matter which are referred to it by the President of India. The advice is given by the Supreme Court is not binding on the President. The President may choose to ignore such advice. The Supreme Court has the power to punish for contempt of court as well. The Supreme Court keep a record of all its judgment which are binding on all courts of India. The Supreme Court has the authority to review the judgment made by it. It also the power of reverse the decision made by it, but only in special cases as mentioned in Constitution. Second is High Court. The High Court head of the jurisdiction of the state and its subordinate only to the Supreme Court of India. The ruling of High Court is binding on all lower courts in a particular states, union territories, but not binding up to higher courts in a country. Some of the courts have jurisdiction over one or two, three states too. There are 25 high courts in India today. Each high court has chief justice and other judges who are appointed by the President of India in the consultation with the Chief Justice of India and the Governor of State concerned. To appoint the judges of High Court, the Chief Justice of High Court also consulted by the President. For the qualification of the High Court judge, the first one, he or she should be Indian citizen. Second, he or she should have held the judicial office in India for 10 years or practice as an advocate of High Court or the subordinate court in a succession of the 10 years. A High Court judge retire at the age of 62 unless he resign or removed by the President. A High Court judge can be removed by the office only if the President pass an order on the ground of proven misbehavior or incapacity. Both the Houses of Parliament have to pass the address for the removal. The address should be supported by the 2/3 vote members who present and voting. Powers and functions of High Court. Powers and functions of High Court are mainly judicial and administrative. In the judicial function, the High Court not only listen to the appeals from the lower court, it can also approach directly to preside over cases that deal with the state's revenue, marriage, law, etc. In its capacity of administrative function, the High Court supervises the functioning of subordinate courts. It can make rules for them and regulate their practice too. The High Court can also withdraw the cases from lower court if it be a question on law of general importance. The High Court also court of the record and it is record all its ruling and decisions for the further use of predictions. India has a very vast area and a population. In increasing the great numbers, each state and union territory of India is divided into districts for the better administration. As we know very well, the High Courts hear the cases in the territory of the states to which it belongs. There are many lower courts in a state belong with the High Court. The courts are known as the subordinate courts. There are 3 subordinate courts that look after the administration of justice in a district in the state. They are as follows. civil courts, criminal courts, and revenue courts. Civil courts that deal with the civil cases. The court of the district judge is the highest civil court in a district. Criminal courts are deal with the criminal cases. The court of the session judge is the highest criminal court in a district. Revenue court are the courts that deal with the cases involving taxation of any kind. It also involves the cases that deal with the collection of and as assessment of land revenue. The Board of Revenue is the highest court in all revenue courts. Nyaya Panchayat and Lok Adalats are also subordinate courts. Let's see about the Nyaya Panchayat. Nyaya Panchayat are courts that try petty civil and criminal cases at the village level. Local people constitute the Nyaya Panchayat. There is a one Nyaya Panchayat for every 3-4 villages. If people are not happy with the decision of the Nyaya Panchayat, they can approach the district court. While Lok Adalat means people courts. It is a voluntary organization that settle dispute among the people. People who have been the legal profession and eminent social worker are the part of Lok Adalat. The Legal Service Authority Act 1987 has legalized Lok Adalats. The decision of the Lok Adalats is a final and binding on the both parties involved in the dispute. This act also ensures that if the dispute is resolved, the court fee paid by the parties will be refunded. Independence of judiciary. Judiciary plays a very important role in the overall development of a country, as they control the distribution of rights and power among the citizen and organization. Independence also helps to keep check on the legislature and the executive. Judicial independence is guaranteed by the Indian Constitution as judges of the Supreme Court retire at the age of 65 and the High Court judge retire at 62. Judges are also granted some privilege, pension, and leaves. Removal of judges are also involved the approval of President and 2 houses of Parliament. The Supreme Court, High Court, and some other district courts that act as a court of record also go a long way in the maintaining the independence of judiciary. Thank you.